Okay, this is in the matter of Enrico Gallegos versus Secretary of State, docket number 20-723AL. And this is the time set for hearing on the petitioner's appeal, asking circuit court review of the Secretary of State's order. And if I could have your appearances just for the record, please.
Good afternoon, Your Honor. Eric Shepard here on behalf of the petitioner, Enrico Gallegos, who is present, and to my left here, we are both in my office, but we are appearing pursuant to video conferencing technology, and we do consent to the hearing being run pursuant to Zoom.
All right, thank you.
Good afternoon, Your Honor. Elizabeth Allen on behalf of the Secretary of State. Thank you.
All right, thank you. Then go ahead, Mr. Shepard.
Thank you, Your Honor. We filed our application and appeal for circuit court review pursuant to MCL 257.323 and its subsections, and then also pursuant to MCR 7.120. We believe we've given the court the appropriate and required materials for the court, which would include the appeal and the actual recitation of the events and arguments that we set forth. We also gave the transcript. Contained within that long package was a copy of my client's master driving record. And then there were two different two different orders from the Secretary of State and Department of State that were included within the packet and package. We certainly rely upon all of the different materials that have been submitted to the court. But there are certain things that I do want to point out to the court by means of oral argument. Certainly, I think the court can allow the opening up of some questioning and testimony pursuant to the statute if the court would allow that, just because of the fact that this is, the Secretary of State considers it to be a medical condition and medical issue for someone who has a substance abuse issue. And I certainly think that the statute allows the court to do that. But if the court is not going to do that and we'll just do oral arguments, then I certainly want to point out a few things to the court. And one of those would be just the fact that hearing officer Clover in this case, he makes really 5 different claims about why he issued a denial order in this case. And the first one was that the petitioner's claims of absence were not supported by the letters. Now, Your Honor, I've been doing these cases for, I would say, at least 11, but probably more like 12 years. And throughout the course of that time, I would estimate that I've probably done hundreds of these cases. And I've certainly, had a high degree of success, thankfully, with regards to these cases. But I've never, until March of 2020, I've never had a hearing officer take issue with that type of language that was contained within these letters that were submitted, the same language that was submitted for these letters. And that is to say that in my letters and in these letters for this case, the letters use language and say that Mr. Gallegos has not used any alcohol or any controlled substances since March of 2017. And that's a correct and accurate statement, but I don't believe that it's inconsistent to the point of reaching a denial decision to say that my client had not used marijuana since 2011. But he had also not used any alcohol or controlled substances since March 16th, 2017. And again, I just don't think that those statements are logically inconsistent with one another. But even if you take that statement into account, even if you take the language of that and to say that, well, the court must conclude that he used marijuana up through March 16th of 2017, that still comports and complies with Rule 13 requirements that he not have any alcohol or controlled substances for a period of 12 months. But the facts and his testimony, the letters, our assessment, all are very consistent that my client did not use marijuana since 2011. And that's also consistent with the prior testimony that he gave through the 2018 denial with hearing officer Johnson, when Hearing Officer Johnson stated in his denial order that my client had not used marijuana since late 2010, early 2011. So all of that has been consistent all along with each other. He's not used marijuana since 2011. He has no interest in marijuana. He doesn't use it. And in this particular client's case, some of my clients come in and they have history with heroin or opioids or cocaine or other controlled substances and illicit drugs. And my client has none of those. Mr. Gallegos never used any type of ecstasy, cocaine, heroin, methamphetamines, anything of that nature. The only controlled substance that he ever used was marijuana, and he stopped using that in 2011. And I think that the language of those letters is not only, I think, sufficient, and it's been inclusively good enough for Secretary of State in the past, but it's also consistent with Rule 13. And I think you have to take a look at everything as a whole. You have to take a look at my client's testimony. You have to take a look at the assessment. You have to take a look at the totality of the circumstances in determining that my client is truthful, accurate, and honest about his last use of marijuana, which again was in 2011. The second condition, or the second reasoning and rationale for Hearing Officer Clover's denial, is that my client appeared very unsure when he actually last consumed alcohol and marijuana. Your Honor, these hearings began taking place pursuant to Microsoft Teams, I believe, and I think June of 2020, because of the global pandemic. And this particular hearing took place on June 18th of 2020. So this was right at the advent of when these hearings started taking place again, just in general, but certainly the very initial process for using and utilizing Microsoft Teams. There's a big difference between a client sitting next to me like Mr. Gallegos is today, and frankly, being able to go and point out to a client, where they may have had their alcohol education class, what they may have taken back in 2010, what their end date was back in 2011 when they did something. And those would be perfectly permissible and admissible under the rules of evidence for recorded recollection. And that's exactly what would happen in the normal course of a hearing when, again, I'm sitting next to my client. But when it comes to Microsoft Teams, I'm sitting at my location, my client's sitting, at his location, and it's just not the same level of process when it comes to, being able to point those things out to your own client, but then also to point them out to the hearing officer. And in addition to that, my client just, became very nervous, in terms of answering the hearing officer's questions. The hearing officer jumped all over the place, jumped all over the map in terms of his questions to my client. And my client was being as truthful and as honest and as open as he possibly could. But I don't think that he gave inconsistent answers in terms of his last use of alcohol or his last use of marijuana. I think he was very consistent and very firm that his last use of alcohol was March 16, 2017, and that his last use of marijuana was in 2011. The third reason and rationale was petitioner's claim that he used marijuana about once per month conflicts with his former testimony that he used it 1 to 2 times per week. Again, I think that this is just completely wrong, incorrect, and inconsistent with the actual testimony that my client gave. And also the assessment that was given through my client, and also the prior orders, that my client at maximum, at his peak, when his peak use of marijuana, he was using it at times 1 to 2 times per week. But the remainder of his marijuana use history, he was using it occasionally, as he testified, and it would be, less frequently and be a couple times per month or once per month, that type of frequency. So I don't think that those things are inconsistent with one another. And I think the testimony and the transcript, and again, the orders and the actual assessment were very consistent with one another. The next reason was that petitioner offered substantially conflicting relapse histories over the course of 3 administrative hearings in 2015, 2018, and 2020. And again, I don't think that that's true, and don't think that that's the case. That my client recalled that he had relapse history when he got the ignition interlock device on in I believe it was February of 2016. He was consistent and said that he had a relapse history in May of 2016. Well, the first alcohol reading and the first alcohol detection was on April 30th, 2016. And then he had 2 subsequent alcohol readings after that. And so again, that is consistent testimony. I mean, he's not exactly right on his date. He didn't say that I had my first alcohol reading on April 30th, 2016. He said May of 2016, which was, a day or two later. But it is true that he had 2 subsequent violations at that time. I just don't think that those things are inconsistent with one another. And I don't think that they lead to some sort of credibility problem or issue with my client in terms of his last use of alcohol. And the last reason was hearing officer Johnson noted that the petitioner offered false testimony when petitioner claimed he relapsed on January 17 in response to the death of his friends, but his interlock reflected alcohol use after petitioner was granted a restricted interlock device. Again, I don't think that that's true. I know that it's true in reading the hearing officer Johnson's order that hearing officer Johnson never concluded that my client gave false testimony. Hearing officer Johnson talked about some inconsistencies, and he talked about some problems that he had with my client in terms of the proofs that he gave, but he did not say that my client gave false testimony. And this is a very clear distinction that the hearing officers make. If they find that there is a significant credibility determination with a petitioner, they state flat out and they say, I think that this person is completely telling me false tales and false testimony in terms of the things that they're saying. That is not what hearing officer Johnson said. He just said that there were some inconsistencies. And as I pointed out in my brief, that in January of 2017, that was when the actual hearing was brought to the Secretary of State. And so again, that's the date that my client was triggering in his head. He knew that he had the relapse events beginning with the initial interlock violation on April 30th, 2016, and he knew he had a second one, and he knew he had a third one. But when my client knew that, he knew he had relapsed, he just decided that he didn't wish to pursue going to that appeal and showing up in person, go through the appeals process, because he knew that he was going to be denied. He knew that his license was going to continue to be revoked. And so he just decided not to appear in person for that. But that hearing took place, that determination took place in January of 2017. So that was the date in my client's mind that to which he was thinking of. So again, all of this is real consistent with the fact that my client doesn't have perfect memory and recollection, and nobody does. And that's why we have the ability and the opportunity for things like recorded recollection. That's why we have the means and ability to look at notes or look at a prior order, look at a driving record, look at iChat for criminal history, look at the form and the petition that you filled out and submitted to the court. But through this process, and having a Microsoft Teams, that was unfortunately not utilized in the way in which it could have been utilized for purposes of this particular hearing that again took place right in June 18, 2020, right after Secretary of State began doing hearings again at all. The bottom line for Your Honor is that my client is very highly motivated to stay and remain sober. He's got 2 children. He's got a 4-year-old son and he's got a 4-month-old son. He's engaged to be married and is in a long-term relationship. His fiance doesn't drink alcohol. They don't store alcohol in the home. The reason they're waiting to get married is because he wants to get the license back and be able to have that additional freedom of being able to live and to work without her constantly carting him around. He's been a cook for Red Robin for a long period of time. He has done that through the pandemic. He's done that through all the challenges that have been forced upon the restaurant industry. And today the indoor dining will begin again, and they will be back to some customers within the inside of the restaurant, but my client's been a cook, and so he's always been there and worked throughout this pandemic and has been a hardworking, productive member of society. So he meets that Rule 13 requirement that he certainly has the ability and the motivation to drive safely and within the confines of the law. I think that this hearing officer got this completely wrong. It's not the first time that I think hearing officer Clover has gotten things completely wrong. And I'm hoping that the court will overturn the determination. I would certainly ask the court to grant my client a full and unrestricted license. I think that he has sufficient proofs and sufficient support system, and he's done the sufficient things necessary in his life to show and to prove that to the court. But certainly the court has the ability to grant an ignition interlock device for the period of time, and he'd have to then go back to Secretary of State. But we're asking the court to grant the full and unrestricted license. I think my client has met the proofs, and I think he's deserving of that. I think he's met the Rule 13 requirements, and we ask the court to overturn the order from Secretary of State and to grant my client his license.
Thank you. Ms. Allen?
Thank you, Your Honor. As we know, there's a standard of review here, and we're looking at whether the petitioner's substantial rights have been prejudiced because the determination of the hearing officer, as argued by the petitioner, whether that determination was supported by competent material and substantial evidence on the whole record, or is arbitrary, capricious, or clearly an abuse of unwarranted exercise of discretion. And I think it's important to note that the hearing officer in this case took into account testimony of the petitioner from 2015, 2018, and in 2020. Not a case where the petitioner came in before the hearing officer and it's a first impression and he's hearing everything or reading it all for the first time. The officer had the ability to review that testimony to determine credibility, which is part of the officer's duty. And as the officer noted, other previous hearing officers found that the petitioner had offered false testimony or at minimum conflicting claims and inconsistencies, and that he did not appear to know when he last consumed alcohol or marijuana. Additionally, he noted the concern the petitioner was not engaged in ongoing relapse prevention programs for long-term support. And because of his serious relapse history, that's a valid and serious concern. So I understand the petitioner's arguments, and I'm sympathetic to all he's worked for and done to get to this point. But the issues here were based on the petitioner's own doing, his prior testimony, his own inconsistencies. He had adequate time to prepare for this hearing that he requested to prepare for these questions. And on behalf of the Secretary of State, we'd have to argue the petitioner has not met his burden to reverse those findings. Thank you.
Thank you. I have reviewed in great detail the findings of the hearing officer. I would put them in three categories, maybe a little bit differently than Mr. Shepard did. But first of all, he took issue with the letters that Mr. Gallegos submitted. Second, he did what purports to be a credibility finding about the conflicting dates, etc. And then third, he took issue with the lack of a relapse prevention program for Mr. Gallegos. So I'll address those three areas. First of all, the letters. The problem that the hearing officer had with the letters is that he says all of his letters indicate he used drugs until March 17. That is so troubling because it is just, it's not even not based on competent material and substantial evidence. It is just false. It is just downright false to say that. It's a complete mischaracterization of those letters. They say that he hasn't used alcohol or controlled substances since March 16th, I think is the date. But that doesn't mean he's used drugs until March 17. Nobody said that. Nobody said he's used drugs. All of the evidence was that his last use of marijuana was in 2011. To just ignore that, and yet that's what Mr. Gallegos said. That's what he said in the assessment as well. To just ignore that evidence and turn it into, because of the wording of the that sentence in the letters to turn it into an affirmative statement that he used drugs right up until March of 2017 ignores the evidence that was presented. Then the hearing officer purports to make a credibility finding, and that has to do with how often Mr. Gallegos used marijuana, his relapse history that he gave over his previous hearings, and when he last consumed alcohol and marijuana. And although the hearing officer put this in terms of a credibility finding, and it appears to be such, it still has to be based on competent material and substantial evidence, and it can't be arbitrary, capricious, or an abuse of discretion. So with respect to the marijuana usage, the hearing officer says that Mr. Gallegos said that he used it once a month, and then that conflicts with his former testimony that he was using it 1 to 2 times per week. But the thing is, they're both true, because at one point he used it 1 to 2 times a week, and at one time he used it once a month. So that ignores the evidence and is not based on competent material and substantial evidence. And then he goes on to say that he gave conflicting relapse histories over the course of 3 administrative hearings in 2015, 2018, and 2020. That again ignores the fact that Mr. Gallegos acknowledged that he relapsed. If you want to call it conflicting histories, it was exact dates. I also have a bit of a problem with using that when he was never given a chance to explain. And I realize these are informal administrative hearings. We're used to something much different in circuit court with much more serious cases. But it just seems fundamentally unfair that the hearing officer pulled that out in his order, but he never asked Mr. Gallegos about it at the hearing. But in any event, it does ignore the fact that he acknowledged all of those things. He just couldn't give dates. And then finally, it says Mr. Gallegos does not appear to know when he last consumed alcohol and marijuana. He offered conflicting claims during his hearing, raising credibility concerns. I just look at that as just downright false and not what the testimony was at all. He said very clearly in the hearing that he last used marijuana in 2011 and that he last used alcohol on March 15th, 2017. Now, there was just one spot on page 7, I believe it was, where there was some discrepancy when the hearing officer was questioning him, and then Mr. Gallegos backed off and he's like, I'm not sure I remember dates. But to say that that and that alone creates a conflict in the testimony that raises credibility concerns ignores so much of the other evidence, which was, again, that he last used marijuana in 2011 and alcohol in March of 2017. That's what his testimony was. That's what he told the assessment preparer, the evaluation, and that's what the letters indicated as well. So I can't, even though I would not normally disturb a credibility finding, again, it still has to be based on evidence, and I don't believe that it was. I think it ignored most of the evidence. And then finally, and this is very troubling too, the hearing officer said, Mr. Gallegos is not engaged in any ongoing relapse prevention program for long-term support. Well, that again ignores the other evidence in the case. That ignores the assessment. The assessment that Mr. Gallegos presented said that he had excellent support, that he understood the relapse process. And it said that under continuum of care recommendations, they didn't even check AA. They checked other and wrote below, continue to utilize positive supports. So the assessment found that Mr. Gallegos had his own support system in his family and friends, and that it was working for him, and that they recommended that he continue that, and they specifically had the option of checking AA, and they did not check AA. So that takes me to the final conclusion that the hearing officer makes. And he says, regardless that his current substance abuse evaluation does not include a treatment recommendation, his failure to attend a support program with this relapse history has simply failed to clearly and convincingly demonstrate that his alcoholism and his drug use disorder is under control and likely to remain under control. Well, I can't substitute my judgment for that of the hearing officer, and I accept that, and I will not do that. But he can't just make things up. He can't just say AA is needed. He has to do it based on evidence, and there was no evidence that AA was needed. And again, the assessment found exactly the opposite, with a good, an excellent community support system with his family and friends. So I think that the hearing officer's decision is not based on competent material and substantial evidence. I also think it's arbitrary, capricious, and an abuse of discretion. And I am reversing the order of the hearing officer, and I'm granting Mr. Gallegos a license, but there is this history of relapse that he acknowledges, and even after a period of sobriety. So I am granting the license with an ignition interlock device that will allow him then ultimately to go back to the Secretary of State. And Mr. Shepherd, if you want to submit an order like that, I will sign it.
I will. Can I email that to Mr. Lewicki by the end of the day today?
Yes,
Thank you, Your Honor.
thank you.
I'll send it to Miss Allen as well.
Okay,
Thank you, Your Honor.
thank you. That'll conclude our hearing.